It's your boy DZ. If you haven't already subscribed to the channel, hit that subscribe button, hit that like button, and share this video. Yeah, we got merch coming soon. You see, we got the SBGB hats. We're gonna have shirts and coffee mugs. So hit that subscribe button and be on the lookout for the merch. The merch will be here real soon. Getting the website set up. But we're going to talk about that YSL case. This is the second judge that's been recused from the case in a week. This judge here came forward and knew that it was going to be some type of conflict of interest in the case. So she came forward without waiting on the problem to happen. She said, I know that one of my deputies had a relationship with one of the defendants, so I don't even want to have any conflict because she works in my office. You understand what I'm saying? She was upfront, knowing that I'm not even going to involve myself in all this mess. Which Judge Glanville, when he knew things were wrong, he should have did the same thing. Let me get out of this situation because I know it's wrong. But he wanted to stay involved because he was already deep in it. He wanted to see it through. But yeah, the judge made a decision to remove herself, and now there is a new judge. And she's white. Maybe she's not going to be biased because you still have attorneys that have relationships with other attorneys and they're biased to a certain extent. And I want to say that when attorneys have relationship with each other, they deal with each other and look out for each other. So in this situation here, being as though that is so public, I know that she's not going to come and jeopardize after what everybody is seeing. She's going to come and make sure she's the referee and not somebody's assistant. I see that. But we shall see. I think that even though that she's been assigned to the case, the defense is going to file a motion for a mistrial. It's a lot going on here. And the judge will have to catch up on 9 months, 8 months of the case, and then the testimony. It would be a lot. It's a lot going on. So I think that it's going to be a mistrial, and hopefully Thug gets a chance to maybe even get a time served plea and come home. Do y'all think that if they were to offer him time served, he would take it? Or would he say, I'm still going all the way to trial? Because he's already knee deep. But time serving to let the case go, in his situation, he had to put that up in the air. Do I want to just get this behind me, or do I still want to fight and try to erase the whole situation? Because that's what he's going to try to do. The new judge on the case is white, though. I don't think you're going to see the same energy that you seen from Mr. Glanville, Your Honor Glanville. Because it's been a circus in there. It's been a live circus. But we're going to check out the motion that was filed from the judge. This is the motion that the judge filed. An order of recusal on or about June 1st, 2023. Christian Ebinger, one of 18 defendants, was served from the ongoing YSL RICO trial on a criminal action that was recently transferred to this court by random assignment. Although there is no severance order in the record, the court was apprised of the circumstances that directly led to Ebinger's severance. More specifically, the deputy assigned to and responsible for the courtroom and personal security of the undersigned for nearly 6 months was arrested. Said deputy, who was still assigned to the court at the time of her arrest, is accused of 1. Colluding with the defendant, Ebinger, during the current trial to commit a felony and 2, endangering the safety of citizens with the Fulton County Courthouse. Because this court former assigned deputy could be called as a witness in any future proceedings in this case, the court may be called upon to assess this deputy's credibility or rule on matters related to her criminal prosecution. This undermines the public's confidence in the impartiality of the proceeding. So she wants it to be fair so that nobody has a doubt about the situation when it comes out that this deputy was in her office and was somehow connected to the judge. While the court does not regard the aforementioned situation as created any actual bias for or against any party to this case, the court does view this matter that could cause a reasonable person to question the court's impartiality and reasonable give rise the appearance of impropriety should the court remain on this case. Rule 211 of the Georgia Code of Judicial Conduct provides that judge shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Commentary to the rule provides that judges should disclose on the record or in open court information that the court believes the parties or their lawyers might consider relevant to the question of disqualification, even if they believe there is no legal basis for disqualification. And that's what the first judge should have did. Just how she's saying that if you think as a judge that this here could be a legal issue, you have to reveal that to the other side. Thus, after carefully consideration and consistent with CJ Rule 1.2a, promoting public confidence in the independence and impartiality of judiciary, requiring disqualification when the public might reasonably question a judge's impartiality, the undersigned hereby recuses herself from the criminal action. Now, what I want to say on that, the judge was smart. That's what I want to say on that. The judge was smart. She knows it's a lot going on, and why am I going to put myself in this? But some people want to be noticed, and then when that big eye is on you and you look that funny and they looking at you like you don't know your job, you wish you didn't put yourself in that situation. That's what happened with Judge Glanville. He looked all over the place. The public got to see how he handles the courtroom when the camera's not on. He's going off his ego. He's not following the rules, the law, the code of conduct. He's going off all ego. And that's what shows. Yeah, he's going off all ego.
Judge Paige Reese Whitaker is now in charge. Another judge had just been assigned, then recused just hours later.
Yeah, this is pretty wild. Atlanta News First anchor and attorney Joy Lim-Nakran has gone through this court order today. And Joy, these changes are happening very fast.
Absolutely. Judge Paige Reese Whitaker will replace Fulton County Superior Court Judge Shakura Ingram. Ingram directed the clerk of court to reassign the case to another judge in her order filed just today. So Whitaker is now the third judge assigned to this case. Remember, Judge Ingram was assigned to the case after Judge Glanville was removed. Judge Glanville had been under fire after Young Thug's attorney filed a motion to recuse him, alleging bias. But impartiality is exactly what Judge Ingram honed in on today in her order of recusal. She stated that one of Young Thug's co-defendants had an alleged affair with a former Fulton County deputy assigned to her courtroom, and she raised concerns about the appearance of impropriety if she continued on the case. Judge Whitaker has been on the bench in Fulton County since 2017 after previously serving as a prosecutor, among other assignments. Blair and Sean.
Yeah, the judge said, I'm getting out of this mess before y'all even put me in the mess.
Couple of hours. That's the highest likelihood of seeing some
you can't do nothing but
storms.
respect it.
85 right now and mug.
You can't do nothing but respect it. She said, I'm getting out of the mess before the mess gets started. The case is going to a mistrial anyway. It's only going to last real shortly. I guarantee you by next week, when their lawyers put the motions in for the mistrial, it's going to go through. How is a judge, a third judge, going to sit in on this case? It's too much craziness. What are the facts? How do we know what the facts are? We have Woody. He done turned into a superstar. They let the star witness turn into a superstar, and he's not cooperating now. Where does the case go? If he was the total focus of their case and they gave him immunity for the case, and now he's going back on what he's saying and he's focused on his star. He got star power right now. He's not worried about cooperating. And he's saying that Thug was a good dude. Now he changed his story to Thug was a good dude. Anything he said in interrogation rooms, he's saying something different now. Thug was a good dude and he shouldn't be in that situation, and he lied about everything. That's where Woody is at with it right now. So if the star witness isn't cooperating, they don't even have a case. The case is dead. I don't know if you guys been paying attention to it as if I have, but the case is dead, man. It's all the way dead. The star witness, Woody, left the building. Woody left the building. Woody's out there doing all kind of interviews now. He got his Instagram popping, got his YouTube popping. He like, oh, this done changed my whole entire life. And a lot of people are in these crazy situations in life because they don't have no money. So they're trying to follow where the money is. That's what they doing. Woody was trying to follow where the money was, and he got involved with Thug, but he wasn't getting no money. Now they got Woody getting to the bag. Straight up. Woody is everywhere being talked about, bag, interview, book. They want to see Woody. I want y'all to hit that subscribe button, man. SBGB merch coming. You see the hat. The hat's about to pop off. They're going to be up real soon. But yeah, Woody then turned into the rat that became famous, and his money is about to escalate. The judge, she sees that this case ain't going nowhere. Why am I going to involve myself in this mess? When the case, when the appeal gets placed in on this, and they go and review Excuse me, not the appeal. Excuse me. When the motion to dismiss gets placed on this, it's going to get granted. Motion for mistrial. Motion for mistrial is going to get granted. You can see it's nothing that is making it whereas though this is a solid case. You have the whole case was based on testimony. The whole case was based on Woody's testimony. Based on Woody's testimony. And they had the guy, Tick, his testimony, all the people that they had that was saying young thug, now they saying something different. It's a whole different story. Where does the case go then? If all the witnesses are saying something different, where does it go? They done threatened all the witnesses that they gonna go to jail, right? So the witnesses said, all right, we gonna testify, but we just gonna say something else. They pulled the reverse Uno on the prosecution. That was what they did. They pulled the reverse Uno on the prosecution, man. I guarantee you, Thug get a mistrial. I can see it coming. Like, for real. Let me see. Let me see here. Let me see. Why is I see the mistrial coming. I ain't gonna lie. I see the mistrial coming. They was so like gun-ho to get this case, they messed it up. This was like a whole bunch of Christmas gifts under the tree, and they was just grabbing all the gifts, and they didn't know which gift to get. Somebody else got somebody else's gift. Who got the real gift? It's messed up. The case is messed all the way up. Let me see here. The case is messed all the way up. It said the YSL, it said, hold on. The YL case, experts agree, yes, mistrial likely. Yeah, the experts do agree that it is going to be a mistrial likely. Let me see here. Hold on. Yeah, it's likely to be a mistrial. Hold up. Let me see here. Let me see what we got here. Hold up. Hold up. Let me see what we got here. Alright, let me see. And they said they had 300 witnesses in this case. Supposed to be 300 witnesses. Let me see here. Hold up. More than 2 years into the sweeping RICO indictment that accused rapper Young Thug and 5 others of running a criminal street enterprise, the fate of the case that involves hundreds of witnesses is being looted as the most expensive in county history is now in question with the possibility of a mistrial looming. We all know it's going to be a mistrial. On Monday, motions filed seeking to recuse Fulton County Superior Court Judge Glanville from the case were granted by the Fulton County Judge Rachel Krause. Defense attorneys filed a motion claiming Glanville showed bias toward the state. After it was revealed in the court, he met with the prosecutor and their witness Kenneth Copeland on June 10th after Copeland had refused to testify prior. These are instances where you can have ex parte communications, deals with scheduling, but one of the requirements is you notify the defense immediately about that. That did not occur. Former Georgia Bar Association President Lester Tate told Fox. He says another key factor in the decision was Glanville's defense of his actions. And that's the thing, though. The judge knew he was wrong, but he tried to defend it. You were supposed to just take that. You got to own up to that. You don't, and it's not like nothing can really happen to him. He's a judge. They're going to move him to another case. Wasn't that bad. That's how they're going to look at it. You don't defend yourself, and that's one thing she put in order. You know what I'm saying? You don't defend yourself. You know what I mean? You don't try to justify when you know you're wrong. And that is what he did. He was trying to make light of that he was wrong. And a ruling Crow said, while the court has no doubt that the judge can and will preside over the case, Young Thug's YSL trial judge Krause denies motion to recuse herself. Hold on, what's this say here? What does this say? Hold up. Okay, so they wanted the judge to recuse herself. The one that decided on the motion over Judge Glanville. Wow, I didn't know that. Okay, let me see what that say. Fulton County Superior Court Judge Rachel Krause has denied the motion to recuse herself from deciding whether the fellow judge should be removed from a massive racketeering trial of a Grammy Award-winning rapper Young Thug. Now, that is one thing that I believe is totally unfair. A judge should not be allowed to make a decision on the motion that's against her. If a judge has a motion against him, it should always be somebody else making a decision on the motion. How you going to make a decision on your own motion? Of course you're not going to agree when somebody's saying you're wrong on your motion. That's one of the things that I say that doesn't make any sense. It said Brian Steele, representing Young Thug, filed the motion based on two factors. Judge Glanville is a colleague, and he made a $2,000 campaign donation to Judge Krause in 2024. Oh, snap. See, I didn't even know that. Judge Glanville made a donation to her, but she still recused him because she knew that. You think about that. She knew he had made donations, but she said, I got to still put this recusal in because it's only right to do it. In her denial, Judge Krause emphasized that the court must consider whether the motion of recusal is timely, legally sufficient, and if the affidavit set forth facts warranting recusal. Krause stated that the court found that the motion timely and legally sufficient, but determined that donations does not warrant recusal as it was not exceptionally large and no additional facts were presented to demonstrate the need for recusal. Okay. And he said she didn't address the fact that her and Glanville are colleagues. So her and Judge Glanville are colleagues. You better understand, though, you cannot trust the system because they will play any game they want when they want. The crazy thing is when they playing games, you don't even know. It's like, why can't I get this? You're not allowed to get this for this reason. Yeah, it'd be a lot of games, man. Let me see. Let's see here. I'm checking for something. Oh, that's me.
Morning here. With me is John Day. He's a defense attorney here in Santa Fe. John, thanks for being with us. Heather Hansen is back at the home base in New York in the studio. And it's just been a crazy day, let me tell you all. It's been a nutty day. It started with a lot of things going on. The defense filed a motion seeking to dismiss this case, saying that the prosecution did not turn over evidence that they believe is exculpatory, meaning it would help Alec Baldwin. And they said, enough is enough. There have been enough problems in this case. And this is what they're telling the judge. There have been enough issues in this case. Judge Marlo Summer, you have given the prosecution chance after chance after chance. You have to dismiss this case. And this is really all over 4 rounds that were turned into law enforcement back in April or so by a man who is a friend of Hannah Gutierrez Reed's father. And so this man, Troy Teskey, who is a former police officer, walked into the sheriff's office and said, here are these 4 rounds. I think you should look at these. These might have something to do with the Rust set. You might have been duped. And so there was a report taken of this a month later, a report written, but it wasn't placed in the Rust file. And then these bullets, these rounds are sealed up in an envelope and then put somewhere else. And so the defense is saying this was buried. The prosecution is saying, I've never seen this stuff until this morning. So there's been a lot of back and forth. There was going to be a motion hearing about this. Then we had a break. The jury was sent home for the day. We had a break and the motion hearing was supposed to continue. Then the prosecution and the defense were huddled out in the hallway talking. And it appears possibly that they might be working out a deal. We don't know that for certain, but it's a possibility. What else could be going on? Because they could have resumed this motion hearing about 45 minutes ago, and that didn't happen. As we always do on these big breaks here, when we're covering these big trials, we're going to be taking your questions. So keep those coming in to us on YouTube, X, Facebook, and Instagram. We'll get to as many of them as we can. So let's get right to the questions. We have one from Jada Hare from YouTube. How did Hannah set herself up? I don't know how Hannah set herself up. Well, I don't think she did.
She's sitting in a women's prison for 18 months. So, that's where she is. I don't know that a setup is necessarily what was occurring. She was taking the brunt of the punishment in this case.
Mm-hmm. Let's go to you, Heather Hansen, on this one. Stephanie AI from YouTube asks, I always thought Seth Kenny, and Seth Kenny is the owner of the prop company, PDQ. I always thought Seth Kenny was greasy when it came to the bullets. Why does that matter for Baldwin? So explain that to us, Heather. Why does this matter when it comes to these bullets?
Because if Seth Kenny did something with the bullets, and the allegation that the defense is trying to infer, if not straight out say, is that he did do something with the bullets to prove a point that the set was unsafe. And if he did, then that would have been, as the defense has said, an intervening cause. It would have been something that would have been to blame for this death and not Alec Baldwin. It's a little bit of a gray area because Alec Baldwin still did allegedly pull the trigger. That's the claim in the case, but it is a big deal and it is a big part of what is going on today with this motion. What happened with that ammunition, and was Kinney doing something, as this viewer asked, a little greasy?
Yeah, and there's a point that the defense has been trying to constantly make here, and it was that Seth Kenny was just way too helpful. He was way too helpful. He brings live ammo into the sheriff's office. Look at my live ammo. And then when he comes down to when they go down to Albuquerque to do the search warrant, to execute the search warrant, he's like, yeah, look around here, look around here. And there was also some talk about how he did have live ammo It's all a little confusing, actually, but there was some live ammo from the set of 1883, which belonged to Hannah's dad. It's very confusing, but really the big kerfuffle is about these 4 rounds that were turned in after Hannah's conviction. I want to go to Dutch Merrick now. Dutch Merrick is an armorer. Dutch, thanks so much for being with me. The prosecutor, this is from Stephanie A on YouTube, the prosecutor is saying none of those bullets match the bullets that killed Helena. Why does it matter beyond they were negligent in filing?
Well, it seems that some of those bullets may indeed match the bullets that were on set. I think the fact that the 6 bullets found on set that happen to be identical visually may be a bit of a tangent, because it seems that this fellow, what's his name, Troy Teskey, who's a police officer, brought in these rounds to the sheriff's station saying, hey, these came from Seth Kenney. These came from the same batch of ammunition, and they're mixed. So I think that the guy that loaded the rounds was mix and matching different bullets and cases and primers, and this proves that they don't all have to match to be relevant. They very much could have come right from the same initial source. And what bothers me most, I think, is that the prosecution has avoided tracking down the origin of the original bullet that killed this person. Like, that is the essence of the entire case, is where did the bullet come from? And I think you're right that Seth Kenney has, or someone had said it moments ago, that Seth Kenney has been sort of squirming around this. I think he's really been leading the investigation. And I see that when I watch the videos of him being interrogated, he's leading that investigator right down a path that steers everyone away from him.
That's a very interesting take from you, as somebody who deals with firearms and bullets and all of those things. This is another question we've got from X now. I like to call it Twitter, the original, but X. At JC Taylor asks, this one's for you, John. Is it just me, or does anyone feel like this entire process is mismanaged? Even the judge seems to be confused on how to proceed with certain things.
Well, this is not unusual in trials like this when, there's arguments over discovery, arguments over what was disclosed, not disclosed. I mean, this judge is trying to run a pretty tight ship, and I think she's done a really good job. And again, I've appeared in front of her a number of times and been yelled at by her a number of times. But I think
she seems to like to yell.
Well, she's good at this, and she does keep things on track. And I think that's what the trial has benefited from, her approach to this. But there's a lot of issues, and the defense is making a lot of headway with the discovery issues and what has and has not been disclosed.
Mm-hmm. She does like to run a tight ship. And, one thing that we saw that was very interesting this morning that I've never seen is a judge come off the bench, put on the blue gloves, open a bag of evidence, and spread out the rounds, and everybody's inspecting the rounds. I've never seen that. But she did say, I don't know what I'm going to do yet. I don't know what I'm going to do yet. So she was going to continue with this motion hearing, and then she didn't. Let's go to our next question. Lisa from YouTube asks, didn't Baldwin hire all these people, including the rookie armorer? That's a good question. Heather Hansen, what do you make of that?
It's a great question, and it's a big part of the civil case. But here in this criminal case, his role as producer is not relevant according to the judge's ruling, and it's an appropriate ruling. Remember, he wasn't the only producer. If we're going to hold producers criminally responsible, all of the producers would have to be held criminally responsible. Civilly responsible, yes, and that's why we see all the settlements, not just with Alec Baldwin, but with the other producers, the other people involved as well. It's a great question. It's a question so many of us are asking, but there's a big difference between the standards in criminal cases, the elements of a case in a criminal case, and a civil case. Civilly, they have been brought to task for sure.
Mm-hmm. Well, there is still another civil case. Actually, there are several, I think, still outstanding, including the one filed by the family of Helena Hutchins, her family members in Ukraine. So Gloria Allred, she's here somewhere. So we still have that suit that's pending as well. Let's go on to our next question. Dutch, this one's a good one for you. Voltic Topic asks, why do armorers not make it mandatory for everyone, including actors, to check every firearm as soon as they are handed it?
Well, we've been doing this for 100 years, and we've gotten a process that is very efficient and gets this done in a way that makes everybody comfortable and safe. Remember, this is an anomaly. This one instance, this one person dying from one live round for the first time, and anyone can remember in Hollywood showing up on a film set, is a very, very different than what we do. I work on a show, SEAL Team. We just finished 7 seasons. And over the course of those 7 seasons, we fired off almost 2 million blank rounds, and we do it safely. If we had the time to show every single crew member all the rounds every time, or even every actor, we would never get anything done. So we have a process where the armor checks the gun, they verify it with the first AD, they can do it in front of the actor if the actor wishes to watch that, but a lot of times the actors are in a character. They don't want to come out of that space. They're ready to act, they remember their lines, they're ready to interact with the other actors, they know their marks, their lighting, all the direction and cues. The last thing they're worried about is, all right, let me get a second set of eyes on that gun. And some actors do. They say, hey, I want to see every round go in, and I get it, and that's perfectly fine. But I think a lot of actors, it's not part of the process, and it's not needed the way we do it. We have 2 sets of eyes making sure it's safe before it ever gets to them.
So you're telling me, you, Dutch, as an armorer, do not show the gun to the actor. You show it to 2 other people who then are part of the process of handing it off to the actor.
It's on a case-by-case basis. I'll give you an example. 2 years ago, when Hollywood was still happening and we were all working and it was in overdrive, I was regular on 2 shows. One was SEAL Team for CBS, and that's an adrenaline-fueled shoot-'em-up show where there's gunfire galore all the time, combat scenes, helicopters, all sorts of stuff happening. And then the other show I was working on was Euphoria for HBO. And now that show is like teenagers with a drug problem in high school, and rarely would they have guns. When we brought a gun out on that set on Euphoria, we would go through every single beat every time, extra safety meetings first thing in the morning before each scene, anyone that wanted to see the gun. And on SEAL Team, where we're a machine, oftentimes we have 8 armors working, and we might have 30 or 40 people firing guns in one take. It's not practical to stop and try to have the first AD and every actor look at every gun and every bullet. It's not practical, so they trust us, 8 of us.
I mean, he's trying to make an excuse why they shouldn't be checking the gun to make sure that the bullet is the bullet for the set and not a real live round. If you doing a scene, you should check and make sure that the bullet is not a live round. I don't care what actor you are. You should check and make sure that these are the dummy bullets, not the real live shit. If it was one bullet in there and that bullet was the bullet that kill her, if he would have checked and made sure that they was all dummy rounds, this situation wouldn't have happened. So he's making it as if you're saying that it's okay to rush to make sure that the weapon is there, but you don't think you should take your time and make sure that it's not a live round in there. That there, like, take it easy. Safety first. And these people get away from that when they're in these positions. Keep your safety first.
To make sure they're all safe, we put them in the actor's hands. And again, the actor can observe it. I'll never preclude an actor from doing that. And on some shows, they're going to look at every bullet and examine everyone. And on other shows, we're shooting thousands of rounds in a scene. So we do it efficiently. And if they want to see it, they can, but they don't have to. That's the point.
This is a good question for you, John. At Tell the 954-8317 asks, so this evidence that Carrie says she hadn't seen this, etc., does this not only impact Alex's case, but also Hannah's appeal? That's a great question.
Good question, yeah. And it could, because her lawyer has this appeal ready to go. And,
right.
Is this an issue that they should have known about? And does it have any sort of significant impact? We don't know yet the answer to that because we haven't seen how this is going to play out. But I think this very likely could be something that plays a role in the Hannah Gutierrez-Reed appeal.
Yeah, and I want to bring up, just to tag on to that, her lawyer, Jason Bowles, has filed a motion calling for her immediate release, asking for her immediate release based on another issue, the fact that they didn't get Luke Haig, one of the experts for the state, that they didn't get his final August 31st, 2023 report. That wasn't turned over before trial. Apparently, Carrie Morrissey, there was an email where she said, this is basically my fault. I thought that I had gotten it to you and I didn't, or what have you. And he's saying, look, she should be released. We're already appealing. And now this. So it makes you wonder, and I'm going to do some work on finding out whether or not they know about these. I mean, you would think they would know because Troy Teske is friends with Phil Reed, Hannah's father, but did the prosecution tell them about these 4 rounds that were brought in?
There are going to be a lot of appellate issues on her case.
Yeah, definitely. Okay, let's go to you now, Heather. At Just Chillin' here. How do you become a special prosecutor? Does it require extra training? And can you tell that Morrissey and Johnson aren't, quote, real prosecutors, meaning Carrie Morrissey is not the elected prosecutor or district attorney. She was appointed by somebody to take this case, as was Erlinda Johnson. How does this process work?
Well,
Heather?
usually in a case like this, for sure, they're appointed. And John may be better able to answer this question because it often depends on the jurisdiction. But they're usually appointed because there are so many pieces of evidence, so many facts. It's going to take so many resources that they want to make sure that there are people that are only focused on this. It's another reason why it is so surprising that there have been so many miscommunications, to put it mildly, about the evidence. But John may be able to speak to how it was done in this case, in this jurisdiction, since he's there.
I asked Corey's wife if it would be okay for me to share that we spoke. She said yes. She also asked that I share with all of you that Corey died a hero, that Corey dove on his family to protect them last night at this rally. Corey was the very best of us. May his memory be a blessing.
After the horrific attempted assassination of Donald Trump in Butler, Pennsylvania, that left 1 person dead and 3 people injured, including the former president, we ask, could the shooter's parents face any legal liability? And before we jump to any conclusion, we break this down with attorney and legal analyst Charlie Langton. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. As we continue to cover the latest in the attempted assassination of Donald Trump, a horrifying shooting that led to multiple injuries and 1 death, I'm not including the shooter who was killed by the Secret Service sniper team, there is something that we have to ask. Do the shooter's parents in any way face legal liability? And I'm going to explain. So authorities have identified 20-year-old Thomas Matthew Crooks as the shooter, the man who opened fire on that pro-Trump rally in Butler, Pennsylvania, from an adjacent roof about 130 to 150 yards away, resulted in injuries to former President Donald Trump, 2 other individuals, 57-year-old David Dutch, 74-year-old James Copenhaver, and tragically, it also led to the death of 50-year-old Corey Compertor, who lost his life while trying to protect his family that day. And as the FBI leads the investigation into the shooter and the lapses in security protocol that allowed this shooting to happen, and we've covered this a lot more thoroughly on previous sidebars, I want to focus on the parents of Matthew Thomas Crooks. So we have Mary Elizabeth Crooks and we have Matthew Brian Crooks of Bethel Park, Pennsylvania, licensed professional counselors. A neighbor has described them as nice people, that this came out of nowhere, that no one expected this. Another neighbor came out and told Crooks' parents, please don't blame yourself, it was not your fault. Reporting indicates that these parents have been cooperating with law enforcement. And in fact, Matthew Crooks apparently told CNN that he was trying to figure out, quote, what the hell is going on, and that he would, quote, wait until he talks to law enforcement before speaking publicly about his son. So it does become a question, though, of how much they knew about what was going on with their son, although we reported that it doesn't seem, based on his cell phone and computer data, there are any outward political ideologies or religious motivations or clues that he was going to do this. In other words, there were no outward points or clues that he was wanting or planning to commit this killing, which makes it just so more eerie. And it seems Crooks was a nursing home worker, no criminal history. His employer, Bethel Park Skilled Nursing and Rehab Center, said his background check was clean. They were shocked by what happened. Crooks was living with his parents in this suburban neighborhood in Bethel Park. It's about 50 miles away from the shooting. But here is where it gets interesting. Authorities have indicated that Crooks used an AR-15 style rifle to commit this shooting using 5.56 ammunition, and that this gun and ammo was purchased legally by Crook's father, Matthew. And I've seen some reporting that the purchase was possibly 6 months ago. I've seen other reporting indicating it was further back, a few years back. But the gun was registered to his father. That's what the reporting indicates. In fact, it was one of 20 guns registered with the shooter's father. That's what's been reported as well. And apparently this was all kept in the home. Now, according to the Washington Post, this type of weapon is very popular. About 1 in 20 adults own this type of firearm in the United States. And it's our understanding in Pennsylvania, background checks are required for long guns that are purchased from a firearm dealer, but they're not required from a private seller. And you don't need a permit or registration in Pennsylvania. And also Pennsylvania allows young people to openly carry rifles in emergencies. And my understanding also is that in Pennsylvania, they don't require gun owners to store their weapons safely. And it's also being reported that Thomas Crooks and his father, they were members of a local shooting club called the Clairton Sportsman's Club. So with all of that in mind, are the parents legally responsible? Can they be criminally charged in any way? And why do I say that? Because Jennifer and James Crumbley, remember them? We covered that case out in Michigan, the parents of the Oxford High School shooter. They were convicted of involuntary manslaughter for their purchase of the weapon that was used in that mass shooting and for their failure to properly store the weapon and keep it out of their son's hands. The jury said in that case it was foreseeable that that could happen. Now, there were some very egregious facts in that case. The idea that on the day of the shooting, they were called into the school because of alarming drawings from their son, but they didn't take him out of school. They didn't use a cable lock on the gun. They didn't tell the school about the gun, that the shooter had apparently told his family he had heard voices, that this shooter had asked his father, James, for help and to take him to the doctor, but James apparently told him to just suck it up. So you had some really, really bad facts to establish that it was foreseeable that their son would do this. But what about in this case? Are we talking about the same thing or is it different? Well, for that, I want to bring on a very special guest, Charlie Langton, attorney, legal analyst, anchor for Fox 2 Detroit, and also WWJ News radio. And I'm here with Charlie. So, Charlie, by the way, what's the call sign for WWJ News? I should know this. I went to University of Michigan.
Yeah, I know. That's great. It's 950, AM 950 on the dial. It's been around for over 100 years. But it was the Crumbley case is an amazing case. And you're a lawyer. I'm a lawyer. So I went to the Detroit College of Law, which unfortunately now affiliated years after I graduated with Michigan State. So there may be a little rivalry. Maybe
that's okay. We'll allow it. We'll allow it here. It's fine. It's all fine. No, and look, Charlie, I'm so glad to have you on. First of all, it's great to meet you. But to be clear, and I want to be very, very clear about this, there is no indication at this point that the parents are in any way responsible for what happened. I can't be more clear about that. But having said that, if the gun was purchased by the father, we do have to ask some questions. So I ask this question of potential legal liability for the parents. What are you thinking about?
I'll give you the short answer is no. And I looked at the very same thing because it struck me, the first thing that struck me was that the father in the Crumbley case bought the gun for Ethan Crumbley, the shooter. And then the father in this case bought the gun for his son, the Trump shooter. But there's a big difference here. Ethan Crumbley, the shooter at the Oxford High School, was 15 years old. This guy was 20 years old. And under Michigan law, and the only way that the prosecutor brought this case was because that the parents have a legal duty to take care of their minor son. And if they breach that duty in a reckless way, then a jury could find involuntary manslaughter. And there are a number of jury instructions on that, and a number of instructions to the jury in both the James and Jennifer Crumbley trial about the duty on a parent to protect the child. And as you said just a minute ago, if you don't store your guns the right way, and if you are reckless in giving a 15-year-old a gun, etc., and not taking the kid out of school when you knew or should have known that the child had some mental illness and could have posed a danger, you breach the duty as a parent. That's Crumbley. But that's not the case here. He was 20 years old, an adult, who under, as I understand Pennsylvania law, I don't practice there, but it's similar to Michigan, is that there's no duty on the part of the parent to take care of an otherwise healthy 20-year-old.
Hey guys, I want to thank you for coming to us as we break down this Trump shooting coverage. And look, one of the reasons we're able to bring you episodes like this is because of the support we get from our incredible sponsors. And I want to call one out, Morgan & Morgan, America's largest injury law firm. Love talking about them because if you should find yourself in that position where you're hurt, and I'm going to read you what the involuntary manslaughter is for Pennsylvania. And it says a person is guilty of involuntary manslaughter when, as a direct result of the doing of an unlawful act in a reckless or grossly negligent manner, or the doing of a lawful act in a reckless or grossly negligent manner, he causes the death of another person. In my understanding, it's a very serious crime in Pennsylvania because it can carry up to 5 years in prison, although it is labeled as a misdemeanor, which I thought was interesting. But anyway, so when you look at that language, you don't believe, even though he was living with them, right, that the parents have any kind of responsibility for storing the gun or for what happens with that gun, right?
No, because there's a superseding cause here is that the 20-year-old, is an adult, the 20-year-old took the gun and shot at Trump and killed other people. So again, you still need a causation element. That may be the definition. And let's assume for the moment that the father was grossly negligent, although I don't know how having 20 legal guns purchased legally, presumably stored legally, although I don't know that, but assuming all that was, I don't even know how you're going to get over the first prong of recklessness or certainly gross negligence. But even if you do get, somehow a jury would say that's all grossly negligent, the cause of the deaths and the injuries would be this adult. And there's no legal duty imposed, unlike Crumley. See, Crumley, you got to go the extra way. When you've got a minor, the parents have a duty. And if you breach that duty, then yes, you cause the injury. It is foreseeable, as you just said, that a minor might get a hold of an illegally stored gun, especially a minor with some mental illness, and then go out and kill someone.
Yeah.
This is not the case here. And I don't read that into the jury instruction that you've got in Pennsylvania. So I don't even think they can bring a charge in this case.
Let me ask you an interesting legal question when it comes to the idea of responsibility and duty and foreseeability. You know, in the Crumley case, you was very clear, at least to me and clear to the jury, that it was foreseeable that not only he could gain access to the gun, but he would commit a school shooting in that neighborhood. Isn't there something for the legal analysis to say this happened 50 miles away? So when you talk about the location of the crime, does that ever come into a factor that this wasn't somebody who took out a weapon and used it at a school, but the allegation was that he took the weapon and then traveled 50 miles to a political rally and opened fire on the former president of the United States? Would you say that matters in the foreseeability analysis?
Yeah, but it helps the parents of the guy. Be my defense.
Sure. Yeah. No. Absolutely.
How's the parents going to know he goes? It'd be better if he shot in the neighborhood, perhaps. But yeah, the fact that he went 50 miles, how can you possibly foresee that he's going to travel 50 miles to find a Trump rally?
I guess my question is, does it matter in general? If somebody, let's say, for example, he was 15 years old. Let's say he was 13 years old. I don't know. Let's 15 years old. And he takes the weapon and he uses it to commit a crime in another state, or he uses it to commit a crime 50 miles away in a further part of the state. Does that matter in the analysis, or will a court or a prosecutor say, hey, listen, it was foreseeable he could have used this gun for violence? That's the end of the discussion.
No, I think that's a good point. And I would argue, if I was representing the minor shooter, that yes, it would not be foreseeable that he would take the gun. It's a very good point. Yes, in the Crumley case, we had the additional argument that there was a piece of paper that was shown to the Crumley parents. It was an hour before the shooting where he drew pictures of, I'm going to kill people, blood everywhere. And the parents said, send them back to school. Well, that did not happen, as I understand the facts, in this case, in the Trump shooting. So I think there are a very significant difference. But your principle is right. You still have to have a foreseeable. But let's change the fact. Let's change the facts even a little bit more. I know that Pennsylvania, as I read anyway, does not have a red flag law. Right. So we have red flag laws, which are basically extreme risk protection orders, meaning that if, and I want to emphasize if, because I don't know the facts well enough of this Mr. Crook's case, the 20-year-old shooter. But if he had mental illness, and he lived with his parents, and then parents had 20 guns, ammunition, maybe even explosives in the house, and the father and mother presumably knew that the shooter had mental illness. Does that pose a duty on the parents to red flag, call the police and say, you know what? We have an arsenal here, and I have a son who is not mentally uptight, or who is mentally ill, remove the guns. So that does, after the Oxford shooting, our legislature did pass a red flag law.
Sure.
Didn't apply in the Crumley case, but it could apply now in Pennsylvania. I will bet you that the legislature in Pennsylvania will look to tighten up at least the red flag laws. And again, I don't know if this person had mental illness, but
let's do the extremes here. Putting the red flag law aside, one of the things that strikes me in this case is reporting that authorities had found explosive materials in the shooter's car, that he had a detonator on him. If there were bomb-making materials that were found in the home and he was living with his parents, and you do let's do a hypothetical here. This is still early, but again, there's no evidence to suggest this. But if they did have knowledge that he was building explosives, if they did have knowledge that he could gain access to the gun, if they even knew what he was planning to do but didn't do anything, could then this be a different kind of case?
yes, I think it could be a different case. And the facts that we're changing, because we're speculating now, if the dad or mother knew that this guy was building up bombs or acquiring weapons and acquiring ammunition, and maybe, I need a little more facts here, but maybe he suggested he didn't like Trump, he didn't like politicians or something like that, I could see a better case being made for the prosecution or the government in this case. Better. Because then there is a link. There's that connection between the illegal activity. I'm assuming making bombs is illegal in Pennsylvania. And if the father knew that his son, I don't care what age at this point in time, were making bombs, and maybe the father bought some bombs, maybe some of these guns or ammunition are used in the bomb making process. I don't know. But even if it was, now there's a better connection between the parents and the alleged illegal activity, and then the connection with ultimately the shooting in the Trump situation. That's a better case. I'm not saying a great case,
sure,
but certainly a better case.
And again, we're not saying that's the facts of this. We're just speculating here about what might. Again, we're playing different scenarios here. And by the way, I will also say, it's come out a lot that Mr. Crooks was a loner, that he was made fun of in high school. He didn't make the rifle team because he wasn't a good shot. He was shy. On itself, all kids have issues. And you can't hold a parent responsible because their child is going through a hardship. You can't say, oh, well, he was bullied, then you should have known he was going to do that, right? The Crumbley case was more of an extreme example, but I think it's important to make that distinction as well. Despite what he might have been going through and even having a tough time, and if he's bullied, if he does commit an act of violence, or a child commits or she commits an act of violence, that doesn't necessarily mean the parents are responsible.
True. Interesting that you mentioned that, though, Jesse. I actually found a lot of similarities in the person and the personality between the Oxford shooter and the Trump shooter. They were both quiet. They were both above average in intellect. They were both loners. They didn't have many friends. They both lived with parents. They both grew up in a fairly well-to-do middle America city. So there are similarities in the makeup here. Doesn't mean they're criminals, right, but it does. Well, actually, it could be criminals, but it doesn't mean that there's going to be a connection to the parents. But I do see a lot of similarities, and even the dads bought the guns in both cases as well. So
and look,
I think it's worth looking at.
I will also say in a lot of mass shootings, that profile seems to be somewhat consistent. I'm not generalizing across the board, but we do see that. Let me ask you, outside of the criminal context, from a civil context, do the parents have to be concerned about anything at this point?
Well, the civil's a different standard, as you know. I highly doubt that any insurance company, if they're going to try to get homeowners coverage, is going to cover the act of their murderous criminal son. So as a practical matter, I would say there's not going to be any kind of insurance coverage here. So if the families want to sue the shooter's parents, I mean, I guess there may be some academic exercise here. Generally speaking, and I did a lot of civil work for many years before I did anything in television or radio, is that we do look for insurance, unfortunately. And if the people, and I don't know how well-to-do these parents are, I haven't looked at them. I would say they're, they're modest means here, so probably not. Although technically, if we can prove that the parents were negligent, just negligent, and what is negligence in this case? Could it be that there were many, many shooters? Could there be warning signs? Again, we don't know. I understand that the authorities, FBI, looking at the shooter's phone records, maybe there's a connection between dad and the shooter. I don't know that, assuming there would be. Dad may have known, maybe that might be negligence. Again, we still have to go through the causation elements. One of them, as you mentioned, shooting took place 50 miles from the house. It's still not probably foreseeable. So bottom line here, even on a civil case, I don't think legally it's good, and practically it's even worse.
Yeah, and look, we're still in the early stages, but every piece of evidence that's come out so far and every indication, even from people who knew the family, said this is all a shock, came out of nowhere. No one expected this, and even one neighbor said to the parents, do not blame yourself for what happened. The parents fully cooperating. So again, no indication that the parents are in any way responsible for what happened here. But I thought it was important to discuss because I know people are wondering about it and wondering about how we got access. But listen, Charlie Langton, you can check him out, Fox 2 Detroit, WWJ 950. Great legal analyst, great attorney, and what a great voice. I can hear.
Oh, man. Yeah, I don't think the parents should bear any responsibility. When your children grow up, you don't know what they're going to do. You don't know what they're going to be into. And in this situation here, the parents didn't know the kid was going to go try to kill the president. That was deep. Yeah. But they took him out. He died. But the crazy thing that I heard earlier was that they were suspicious of this guy an hour before he did the shooting. And this guy was on their radar an hour before. So they're asking to look into the Secret Service, whoever runs it, to see if he should step down because they were suspicious of this guy before he did that. Damn. If they knew that this guy was going to attempt to shoot the president and they didn't get on top of that, they fumbled the ball for real. They really fumbled the ball. Because being as though that it is the president, any kind of threat that they feel, they supposed to address it with seriousness. And an hour before, and this guy had a chance to get up on top of a roof and shoot shots, that's deep. But y'all leave a comment, man. Let me know how y'all feel about the situation, man. Let me know how y'all feel about the YSL judge recusing herself, if the YSL case is going to get a mistrial. Let me know, man. We got the merch coming, the SBGB hats coming, shirts. So hit that subscribe button. Share this video, man. Hit that like button. It's not about the setback. It's about the get back. Now.